syllabus. Yung law on trademarks, we start on law on trademarks, then you have the law on patents and the law on copyright. But again, all these three laws are included are all in our Republic Act number 8923 or the Intellectual Property Code of the Philippines. Okay, so what is intellectual creation? Okay, this is one of the modes of acquiring ownership under the Civil Code. Okay, it is one of the 7 enumerated under that provision of the new Civil Code. It is considered to be one of the 2 original modes of acquiring ownership under the new Civil Code. So original po to ha. Okay, hindi siya derivative mode of acquiring ownership. Ng example po natin doon ay, let's say for example, tradisyo or delivery. That is the mode of acquiring ownership in contracts like contracts of sale. Okay? Pero ang intellectual creation, it is not a derivative mode but an original mode of acquiring ownership. So ito yung pinaka first na transfer ng ownership, unlike in tradition that it could have been subjected to further transfers already. Okay? Yan po yan. So still intellectual property, those property rights which results from the physical manifestation of an original thought. Okay, it's a manifestation of an original thought. Okay, intellectual property rights are also said that they are about economic interests because intellectual property includes substantial financial interest in investments, employment, awarding of contracts, purchases, leases, sales, or similar matters. Okay, so as an overview, these are the types of property that we know of. Meron tayong real property like land, tangible personal property like cars, jewelry, or clothing, and of course, we have intangible personal property to include itong intellectual property. So, examples po natin dyan, of course, patents, copyrights, and trademarks. So, on intangible personal property, that is our focus. Okay, if we are to talk about intellectual property law. Okay, and it is said that the country, the Philippines, has a solid intellectual property rights regime in place, although the implementation and the enforcement are inconsistent. Okay, so the Intellectual Property Code provides the legal framework for intellectual property right protection, particularly in the key areas of patents, trademarks, and copyrights. Okay, so that's the role of the Intellectual Property Code or Intellectual Property Law. So Philippine laws then, still on Philippine laws, we have this provision of the Constitution again, which is the legal basis for the subsequent legislation of the Intellectual Property Code. Kaya sabi dito, the state shall protect and secure the exclusive rights of scientists, investors, artists, and other gifted citizens to their intellectual property and creations, particularly when beneficial to the people, for such period as may be provided for by law. So the protection is time-bound. The protection is not forever. Okay? So, ito, tingnan natin. It's a restriction to this property right of ownership over intellectual property. It says here, the use of intellectual property bears a social function. This too is found under our Constitution. It is considered to be a limitation, I repeat, to one's intellectual property rights. Okay? Because similar to other restrictions to property rights, okay, one is supposed to act with justice, integrity, and good faith in all his undertakings. Okay, we also have to respect the rights of others while enjoying our rights. Okay, we need to exercise our rights, okay, not to unduly prejudice that of an innocent third person. Okay, so these are just some of the restrictions to one's exercise of intellectual property rights. Pero sabi nga natin, okay, balik tayo sa general rule, when we enjoy that ownership rights over our intellectual properties, this enjoyment, this full control that we have over our intellectual property rights will not be forever in protection. Okay? It was said that the monopolies that the law grants creators and inventors are incentives so that eventually their creative output and useful inventions may be made available to the public. Okay? So parang binibigyan tayo ng pagkakataon na intellectual property rights owners to maximize what we have. Okay, so dahil tayo ay gumastos sa pag-recreate nito, okay, kailangan din natin makakuha ng balik doon sa ating kapital na ginamit para ma-develop itong intellectual property na to. Okay, so we're given that sufficient number of time or protection. Okay, so essentially, okay, what happens is that after a period of time, these intellectual property rights that we have should now be available for public use. Okay? So, it's the time na meron po tayong term of protection na tinatawag under the law. After this period, yung term of protection, the creation is now of the public. Kaya open source na po yan. Okay? Yan. Let's now proceed. So what are the governing law and rules on the matter of intellectual property rights? We have, of course, the primary law on the matter, okay, RA 8293, which has been amended, okay, by this series of Republic Acts 9150, 9502, and 10372. So may mga amendments po dyan na nangyari. Also, on the implementing rules or yung rules mismo, okay, implementing the Intellectual Property Code, we have to refer to the Rules of Procedure for Intellectual Property Rights cases. Okay, this is issued by the Supreme Court. Kaya administrative matter po ang kanyang denomination po dito. Okay, so we have here our illustrations. Okay, a diagram of the intellectual property rights that we may possess under the Intellectual Property Code. Okay, so hindi lang po siya trademarks, service marks, trade names, meron tayong patents, meron tayong copyright, meron din po tayo intellectual property rights na utility models, industrial designs, performance rights, rights of producers of sound recordings, right of broadcasting organizations. So these are examples of intellectual property rights. Okay? So true or false tayo. Under Intellectual Property Code, to be covered by the law, it is required that you register your business in the Philippines. Is this true or false? Dwell on it for a while. Under the law, okay, for us to enjoy protection, do we need to register our business in the Philippines to enjoy intellectual property rights protection? Okay, I simply restated the statement. Okay, true or false? Okay, so tingnan natin. This is the suggested answer and it is the answer. Under Intellectual Property Code, to be covered by the law, it is required that you register your business in the Philippines. This is not true. Okay? So, what is registered really is, okay, pursuant to the code, okay, to the proper appropriate government agencies to obtain protection or to enforce owner's right is a person's intellectual property rights. Hindi po yung business, kundi yung intellectual property rights. Okay? Magkaiba po. So the following points are of our primary concern in relation, of course, to the CIPALE syllabus. Okay? Trademarks, patents, copyright. So, still, what law governs trademarks? Kasi trademarks, I think, will be relevant source of questions for certified for the CIPALE examination, lalo pag komersyo ang pinag-uusapan natin, no? Okay? So, ano kaya yung governing law on matters of trademarks? Okay, it will still, of course, be the special law on the matter, intellectual property law, intellectual property code, yun yung primary law. But on the matter of trademarks, we should also adhere to TRIPS na sinasabi. And what is TRIPS? This is the World Trade Organization, WTO, and to which other countries also are a member. Okay, we adhere to the agreement on trade-related aspects of intellectual property rights. Trade-related aspects of intellectual property rights, TRIPS, okay, WTO, and its membership. So we should adhere to that. Other than that, meron din po, okay, we should also adhere to the Berne Convention. Okay, pag usapin naman po ito ng copyright, okay, ito naman po pag usaping Madrid Protocol, okay, it has an effect also on the discussion on marks. Okay, marks, trademarks, service marks. Okay. So since the Philippines is a signatory to numerous treaties protecting intellectual property rights, the claims of convention priority or priority dates are acknowledged and respected. So ibig sabihin dapat may reconciliation ng ating Philippine application of the applicable law with, of course, the conventions that we are a member of. Okay, yun naman po yung pinaka-importante dito sa particular slide nito. Okay, I wish to stick to the basics, so I need not talk about some of the examples here in this slide. Okay. So sabi dito, okay, significance of us studying intellectual property law. modern markets are not anymore limited to local consumers. Okay? So marami tayong transnational transactions, no? Okay. Businesses are becoming global and cater to both local and foreign markets. And as a result thereof, trademarks, brand name, trade secrets, inventions, and designs are exposed to a larger market. Hence, the need to secure protection for these intellectual properties. Okay. So, IPR, intellectual property rights, primarily protected and enforced in the Philippines through the Intellectual Property Code, okay, and the rules of the Intellectual Property Office and other government agencies. Remedies in connection with enforcement of intellectual property rights, such as injunctive, relief, damages, may also be secured by the holder of the intellectual property right from the civil courts. So, interrelated po yung ating mga different arms of the government. Okay, we have of course here the executive, and okay, meron din tayong mga meron din po tayong mga remedies before the court. Okay, so judicial remedies, administrative remedies. Okay, the executive of course is in charge of the implementation of the law. IPO, okay, Intellectual Property Office. This is the office that processes applications for trademarks, service marks, trade names, patents, and all the other IPR that were intellectual property rights that were mentioned a while back. Okay? However, yung copyrighted works, pag copyright ang pag-uusapan natin, they are deposited with the National Library or the Intellectual Property Office, as well as the Supreme Court Library for copyrighted works in the field of law. Okay? So, medyo kailangan pag copyrights ang pag-uusapan, hindi lang isa, kundi dalawa, at times tatlo, ang kailangan nating pagdepositan ng copyrighted works. Okay? Overview of trademarks, patents, and copyrights. How will we compare or distinguish one from the other? So, trademark, copyright, and patents are different intellectual property rights that cannot be interchanged with one another. So, a trademark is any visible sign capable of distinguishing the goods, yung TM dyan, no? Or services of an enterprise and shall include a stamped or marked container of goods. In relation thereto, a trade name means the name or the designation identifying or distinguishing an enterprise. So, pinopoint out na ang trademark ay different sa trade name. Okay? So, the scope of copyright, on the other hand, is confined to literary and artistic works, which are original intellectual creations in the literary and artistic domain, protected from the moment of creation. Okay? So, may mga remarkable features po yung copyrighted works in relation to those that enjoy trademark protection. Anyway, we will go through this in the next slides on that particular law. Okay? So, in the meantime, however, what we need to know now is patent. Okay? So, patentable inventions refer to any technical solution of a problem in any field of human activity which is new, involves an inventive step, and is industrially applicable. So, sa overview pa lang, makikita nyo na, okay, very distinct pala. Hindi pala dapat i-interchange itong mga intellectual property rights na ito, trademark, copyright, and patent. Okay? So, this is just the overview. So, difference between copyright, patent, and trademark as to the subject matter. Okay, pag copyright, literary, scientific, or artistic work. Okay, that's copyright. Pag patent, new, useful, and industrially applicable inventions. Okay, so of course, hindi lang sa inventions, we also have utility models. Okay, else trademark, pag goods naman po, manufactured or produced, or even pag service mark, services naman po. So, where rights are registered for copyright, National Library, for patents and trademark before the Intellectual Property Office. Okay. Duration of the right, just an overview. Okay, yung protection, yung term of protection na sinasabi natin. Pag patent, 20 years from filing or 20 years from the priority date. Trademark, 10 years. Copyright, generally up to 50 years. This is the general rule because the reckoning period will depend on the kind, okay, of that copyrighted work. Okay, so tingnan nyo po yung mga general terms of protection natin na meron sa batas. Okay. So, pag trademark, shorter. Susunod patent, pinakamahabang protection, copyright. Okay? Ayan. So, now, we focus on the law on trademark. The law on trademark. These are examples of registered trademarks that have enjoyed protection. Okay? So, you might be familiar with some of them. Others, siguro ngayon nyo lang nakikita. Okay? Okay, nakita nyo dito, pati pangalan, no? Pwede i-trademark po yan. Okay, Facebook, of course, banks, okay, mga gamot, mga hotels, okay, accommodation, facilities, food, of course, yan na yan. So, these are examples. Many more. So, on signs, if you see this sign, okay, this is to signify to us that it is a registered trademark or symbol. So, pag may kayo mga makikita dyan, mga balot ng inyong mga products na pinamili, tingnan nyo kung it enjoys registered protection as a registered trademark. TM is used for marks that have not been registered. Okay, and the registered trademark symbol provides notice that the word or the mark has been registered and is protected by law. Okay, so yung mark na yan o yung word na yan, it would refer to a logo, a symbol, a word, or words that may be registered for representing services or products. In the previous slide, you actually see examples of logo, symbol, word, or words. Okay, yun po yan, example natin. Okay, let's try to distinguish legal name versus trade name versus trademark. Okay, the legal name of a business is the name of the person or the entity that owns the business. If the business is a partnership, the legal name is the name given in the partnership agreement or the last name of the partners. For corporations, the business legal name is the one that was registered with the SEC. Okay, so legal name, legal name. Okay, a legal name should be used when communicating with the government or other businesses. For example, the business legal name should be used when filing tax returns, buying property, or writing checks. Trade name, on the other hand, okay, it is the name of a business uses for advertising and sales purposes that's different from the legal name in its articles of incorporation or other organizing documents. It can also be referred to as, also known as, or doing business as. Okay, so an examples po natin dito. Trade names are the use of the name Kodak by the company whose legal name is Eastman Kodak Company, or McDonald's by the company whose legal name is McDonald's Corporation. Although a trade name may sometimes also be a trademark, sometimes a trade name is not in itself a form of intellectual property. So yung trade name is not the intellectual property, but it is that trademark which is considered to be the intellectual property. So the name or the designation identifying or distinguishing an enterprise is the trade name. Okay? So magkaiba ulit ang trade name sa trademark. At dahil iba ang trade name sa trademark, kaya iba yung rules natin sa trade name. Okay? So there is no need to register trade names in order to secure protection for them. Kung trade name man yan, technically it is governed by SRC rules. Okay? At hindi po sa IPC or Intellectual Property Code. Okay. So, trademark. Let's now focus on trademark. Okay. A question will be, if one is interested in filing a trademark application in the Philippines or wish to protect his business brand or trademark, what are the things that one should know about trademarks? Okay. So, technically, ang unang tanong dyan is, what is trademark? No? So, ito yung legal definition na nakita nyo na kanina when we were attempting to have that overview, okay, ng intellectual property rights. Okay, so yung trademark again is defined as any visible sign which is capable of distinguishing the goods pag trademark or services pag service mark. Okay, distinguishing the goods trademark, distinguishing the services, this is service mark of an enterprise and shall include a stamped or marked container of goods. So hindi lang po yung visible sign, pati yung mismo kung nasaan siya naka-stamp o yung mismong container na naka-contain kung saan nakalagay yung iyong marka. Okay? So, thus, a mark must be a visible sign. Okay? Visible sign. And must be capable of distinguishing one's goods and services from those of another. So, may dalawa pong requirement para ma-consider siyang trademark. Visible, okay? Hindi na imagine mo lang. At capable of distinguishing one's goods and services from those of another. Okay? So, trademark. It shall be any visible sign. Kaya pag sound lang yan ng musical instrument, hindi. Pag amoy lang yan, scent of a perfume, hindi rin. Kasi hindi nga siya visible sign, no? So that cannot be registered as trademark. So other examples of trademark that we have here, any combination of the above, meaning yung mga signs, logos, and can even be a slogan such as, of course, itong kay Coke. Okay, matagal na po itong It's the Real Thing. It's really cooks. Okay. The Nike swoosh is a trademark, as it is the Gap logo and thousands of other familiar symbols and logos. Trademark. Why should you register your trademark? Okay, may mga purposes po na naka-indicate dito. Okay, so your trademark distinguishes, as we have said, your goods from others. It represents your business identity, your image, your reputation that sets it apart from your competitors. Your trademark is your asset and property. So it is worth a lot of money. Okay? Kaya yan po yung siguro pinaka-practical na dahilan kung bakit kailangan mong i-register, kailangan mong i-protect yung trademark na yan. Okay? And bukod sa mga na-mention po dito. Okay? Please take a reading of that. Also mentioned in your handout. Okay. This is an attempt to compare again trademarks with trade name. What needs to be protected under the code in trademarks and the trade name. Collective mark. Okay. How is collective mark defined? Any visible sign designated as such in the application for registration and capable of distinguishing the origin or any other common characteristic, including the quality of goods and services of different enterprises which use the sign under the control of the registered owner of the collective mark. So, it's really more on branding, di ba? May mga mark talaga na pag itong nakikita mo, you associate it with different products. Okay? Usually, minsan pag itong kumpanya, madaming product line, pero as a company itself, may sarili siya na marka. Okay? What is the objective of the law in protecting trademarks? The purpose of the law in protecting trademarks is considered to be twofold: to protect the owners in his property and to protect the public from being deceived by reason of a misleading claim. Okay. Okay. Mark. Visible sign, distinguishing goods or services of an enterprise. Yeah, you know that already. What's the difference between the two? Trademark and service mark. Okay. Trademark, sabi natin goods. Pag services, service mark. What else? Pag trademark, may mga listahan tayo under the intellectual property rules. Okay, kung ano yung mga goods na ito that may be registered. May mga different classes yan. Tinatawag natin international class 1 to 34. So, mahaba po yung listing na yan. Okay, pag service marks naman po, okay, pag kayo nagpa-register ng service marks, may mga category din po yan. And it is found under international class 35 to 42. So, parang 42 yung ating classifications. Okay, so 1 to 34 refers to trademarks, 35 to 42 on service marks. Okay. How are rights to a trademark or service mark acquired? Okay. Under Section 122, sabi doon, the rights in a trademark shall be acquired through registration made validly in accordance with the provisions of this law. Okay. So, valid registration. That's the short of it. So, is it required that my trademark cover goods or services that I am presently selling? That could be a possible question. What if I am not yet using my trademark? Can I file an application already? Okay. So, anong sagot natin sa katanungan yan? No, an application for registration may be based on actual use or, kung hindi actual use, intended use of the mark in the Philippine commerce. Okay? So, intended use of that mark in Philippine commerce. Prior use of a mark in the Philippines is not necessary to file an application. Okay, this is the new rule. Prior use in the Philippines is not necessary to file an application for registration of that particular trademark. Okay? The use of mark becomes necessary only after the application, okay, for its registration has been filed. Okay? So, application for its registration has been filed. Okay? After you have already made the application, doon na po papasok si necessity for prior use. Because, okay, a declaration of actual use in Philippine commerce is required to be submitted within a number of years from filing date. Okay? So, pag kayo nag-apply, hindi pa kailangan na ginagamit mo na. Pero pag nakapag-apply ka na, kailangan ka na din mag-prove na meron kang declaration of actual use. Okay? So, how are rights to a trademark or service mark acquired? We have this provision, of course, sa rules. If you are able to have identified in the minds of the public that those goods, okay, the services that you have, okay, pertains to you, then you are what? Okay, that you may acquire it through use. To better understand this, I think it's better to state that the rights to a trademark are actually acquired. You acquire the rights to a trademark, okay, through registration. Kaya ka nga nag-apply, no? Through registration to the Operative Act with the Bureau of Trademarks of the Intellectual Property Office. So, may Bureau of Trademarks tayo sa IP office. Okay? Once na na-register na yan sa kanila, okay, that is the Operative Act. That is the Operative Act that will now grant you the rights to your trademark. Generally, protection against infringement is accorded only to marks duly registered with the Intellectual Property Office. That's a general rule. Okay? So priority of rights in a trademark is not anymore based on prior actual use, but on prior filing of an application for registration. Okay? So why is it important to file an application with the Intellectual Property Office immediately? Because the IPO observes the first to file rule. Okay? Thus, if you filed an application for a mark, no one can file an application for the same mark anymore. Okay? Yan. Ganyan ka-importante na ang libro ng ating Bureau of Trademarks sa Intellectual Property Office ay talagang updated, not as available always, so that you can take a look at, baka meron na nga palang nauna na nag-file ng application for registration of a particular trademark. Okay? So, meron tayong doctrine of secondary meaning. And what is this doctrine of secondary meaning? And how is it relevant to the law on trademarks? Okay, so while a generic, indicative, or descriptive mark will, as a general rule, be denied registration, there is a circumstance that will allow it to be registered. Bakit general rule ay denied siya? Kasi it doesn't create a distinguishing feature. Hindi siya distinguishing that would, the feature is not specific or distinguishing that it will place in the mind of the public that indeed that is your own. Okay, the second element actually is missing. Okay, although it may actually be visible, but if the second element lags, then apply the general rule. It is not supposed to be registered. You should deny registration. Pero meron tayong exception to that general rule. Ito po yun, exception to the general rule. Under this doctrine of secondary meaning, when a mark has become distinctive of the applicant's goods in commerce and in the mind of the public, it indicates a single source of consumers. It may be registered. Minsan to yung mga collective mark na sinasabi natin, no? Okay, so it has already created this doctrine of secondary meaning. So, pwede natin sabihin na even before you applied for registration of this particular trademark, okay, it has already reached this level of cognizance by the public, no? Yan po yan. What are the territorial limits of a trademark? It has no territorial boundaries or states of nations, but extends to every market where the trader's goods have become known and identified by the use of his mark. So, pwede siyang, tawag nito, extraterritorial ang recognition, ang application, at ang implementation. In what cases is the registration of a trademark or service mark not allowed? Another way of understanding this is what marks cannot be registered. Okay? Ano daw hindi natin pwedeng i-register? So, kung meron tayong dalawang test kanina, that it should be visible sign. Pangalawa, it should create this distinguishing character in the minds of people to separate your goods or your services from the rest. Okay? At tingnan natin kung ano yung mga examples ng mga hindi nakamit doon sa mga requirement na yun. Okay? So, a mark can be registered if it consists of immoral, so contrary to what? Morals, no? Immoral, deceptive, or scandalous matter, or matter which may disparage or falsely suggest a connection with persons, living or dead, institutions, beliefs or national beliefs, or bring into contempt or disrepute. Consists of the flag or coat of arms or other insignia of the Philippines, or any of its political subdivisions, or of any foreign nation, or any simulation thereof. What else? Madami to, mahaba itong listahan na to. Okay? So, we also have this. Consists of a name, portrait, or signature identifying a particular living individual, except by his written consent, or the name, signature, or portrait of a deceased president of the Philippines during the life of his widow, if any, except any written consent of the widow is given. Okay? So, those mark, it cannot be registered if it is identical with the registered mark belonging to a different proprietor. Kasi na first in, first out ang ating rule. Okay, so continue to read this. I think this is found also in your handouts. Others, okay, ito, common. Those that are identical with or confusingly similar to or constituting a translation of a well-known mark, whether or not registered in the Philippines and used for identical or similar goods or services. Identical with or confusingly similar to or constituting a translation of a well-known mark which is registered in the Philippines, kanina doon which or not, no? And used for goods or services which are not similar. To related to similar goods to not similar goods. Okay, yan ang number 4. Yung number 5, likely to mislead the public, particularly as to the nature, the quality, characteristics, or geographical origin of the goods or services. Okay, baka nakalagay na logo. Yung mark is somehow saying that it came from this particular state. Okay, a state that is known for those particular products, and yet hindi pala totoo, no? A mark cannot be registered if, yan, consists exclusively of signs that are generic for the goods or services that they seek to identify. So, ano kayo mga generic marks na yan? That when you relate it to a particular product, ay, sandali, common ata yan. Talagang pag ganyan na wala pag-uusapan natin, ay talagang libro naman yan. Common, generic. Okay? So, a simple image of a book alone, okay, without add-ons, it's a generic sign. Okay? Yan po yan. It consists exclusively of signs or of indications that have customarily or usual to designate the goods or services in everyday language or in bona fide and established trade practice. Okay, consists exclusively of signs. Okay, ano yung maigi, ano? Exclusive generic signs. Yan po yung commonality ng slide na ito. Why they should not be registered. This portion, on the other hand, okay, it consists of shapes that may be necessitated by the technical factors or by the nature of the goods themselves or factors that affect their intrinsic value. It consists of colors alone, again, exclusive to shape, ito color. Okay? And of course, sabi ito, contrary to public order or morality. Ano yung term of protection for trademarks again? Remember this, 10 years. This is the reckoning, this is the period from the reckoning point. Ito yung reckoning period natin from the filing date of the application. Filing date of the application. Provided that the registrant shall file a declaration, ito na yung sinasabi natin, declaration of actual use, no? Upon application, hindi kailangan, pero pagka-file ka na, dapat, okay, meron ng actual use. Take a look at the times, the period of time. Ano po yun sa inyong timeline na kailangan kang mag-submit ng declaration of actual use. So, what rights does the owner of a registered trademark or service mark have? Okay, the owner of that registered mark shall have the exclusive right to prevent all third persons not having the owner's consent from using in the course of trade identical or similar signs or containers for goods or services, which are identical or similar to those in respect of which the trademark is registered, where such use would result in a likelihood of confusion. So we simply avoid the likelihood of confusion to associate one's goods or services, okay, to that of yours when you are enjoying this protection for having it registered first. In case of the use of an identical sign for identical goods or services, a likelihood of confusion shall be presumed. Okay, so this is a rebuttable, this is a disputable presumption. Who has the burden of proving the contrary? It is that person. Okay, it is that person who is alleged to have done the infringement. Okay. What are the rights conferred? We see it under Section 147 of the Intellectual Property Code. Okay? The owner of a registered mark shall have the exclusive right. Ito yung mention natin kanina. Okay? It is seen under Section 147. What are the rules on assignment and transfer of application and registration of trademark and service marks? So during the application process, okay, can it be transferred? Can it be assigned? Okay. The rule says yes, but it has to conform strictly with these rules. An application for registration of a mark or its registration may be assigned or transferred with or without the transfer of the business using the mark. Okay, so we learned again to separate yung intellectual property, okay, from the business itself. Kaya the business can transfer it to another one, and it does not necessarily mean that kino-contain, kailangan mong i-contain within the business yan. Hindi po. The assignment of the application for registration of a mark, or if its registration shall be in writing, the formality requirement is it should be in writing and would require the signature of the contracting parties. Transfers by merger or other forms of succession may be made by any document supporting each transfer. Assignments and transfers shall have no effect against third parties until they are recorded at the office. Okay? Does the owner of a trademark have a right of property to prevent others from manufacturing, from producing, or selling the same article to which it is attached? Okay? May ganito bang right na ini-enjoy ng owner ng isang registered trademark? Okay? To actually prescribe businesses to manufacture, to produce, or to sell the same article to which it is attached? Parang sobra naman, no? Okay? So the answer really is no, hindi po yun yung kapangyarihan ng isang registered owner ng trademark. Okay? Hindi po yun. Okay? So if you are to take a look again at the protection that is granted under the law, that's not, okay, the intention. Okay? The basis of registration is actual use in commerce in the Philippines. Before an application, this has already been amended. This has already been amended by the new rules. Okay? So let us forgo with that. What is the prohibitions on the use of trade names? A trade name or designation may not be used as a trademark, may not be used as a trade name if, by its nature or the use to which such name or designation may be put, okay, is considered to be contrary to public order or morals, if in particular it is liable to deceive trade circles or the public as to the nature of the enterprise identified by that name. Okay? Saan mo ito makikita? Actually, this has already been discussed, okay? But you just relating it to your business associations, like pag discuss natin yung sa pangalan yung corporation, the corporate name, and partnership name. Yun po yan. What are the tests to determine confusingly similarity between marks? Okay, so what are the tests to determine whether there is trademark infringement? It's one way of understanding this particular slide. Okay, there are two tests, the test of dominancy and the test we call as holistic test. So ano yung dominancy test? The test of dominancy requires that if the competing trademark contains the main or the essential features of another, and confusion and deception is likely to result, then infringement takes place. So, kailangan i-compare mo, no? At kung ito ay laman niya ay yung mga essential features ng itong isang ito, then likely yung third person dealing with these two marks, if they would likely be confused and deceived, we have infringement. Okay? So, duplication or imitation is not necessary, nor is it necessary that the infringing label should suggest an effort to imitate. Similarity in size, form, and color, while relevant, is not conclusive. Okay? Again, i-compare mo lang yung dalawang signs. And if it will result to this, then that is dominancy test, okay, of infringement ng trademark. Okay? So may MCQ tayo dito. It is a way of determining whether there exists an infringement of a trademark. Suggested answer. We simply focus on the similarity of the prevalent features of the competing marks, which might create confusion. That is the test of dominancy. So, dominancy test focuses not simply on similarities in size, form, or color, but on the main or essential features of each mark taken together. It requires that if the competing trademark contains the main, again, or essential features of another, and confusion and deception will now be likely to result. Yan na yan. Ano yung second test? Holistic test. Confusion of goods and confusion of services. How may this happen? It would consider the mark as a whole and not as dissected. It focuses on the mark as a totality, not usually to any part of it. Okay? So, ang real test natin sa holistic would be, ano yung apparent effect to the buying public? Would the buying public, okay, although hindi siya yung prevalent feature ng itong other registered trademark, okay, pero pag sa buying public ay i-consider niya na parehas naman, di ba? Okay? So, again, the gauge will be, would it affect, okay, the buying public's, okay, identity of your particular trade name. Let's try to compare the two. Dominancy and holistic. What it focuses on. Sa test of dominancy. Sa holistic, ano po? Saan po tayo nagko-concentrate? Okay. And then, you take a look at the effect. What is the likely effect? Okay. We have this case, August 16 of 2010. Okay, so Myra Pharmaceuticals, the owner of an earlier registration for Dermalin. Ito po yung trademark, yung Dermalin, in International Class 5 for pharmaceutical products. Dermalin applied to register its Dermalin Incorporated trademark in International Class 44 for various skin treatments. So, ang kino-contest po natin dito ay yung Dermalin na walang E at yung Dermalin na may E tapos sa ilalim niya may nakalagay na Dermalin Incorporated. Okay? So, contesting, no? Opposing na trademarks. Applying the dominancy test, Dermalin, and the second line, Dermalin Incorporated, the second mark, so resembled its trademark Dermalin, the first mark, that its registration would likely to confuse and deceive the purchasing public. Okay? Kasi pag narinig mo yan, kahit visible sign yan, example natin, pero minsan pag may public ad sa radyo, pag narinig mo lang, at parehas siya sa isang nauna ng product who enjoys registration protection, you might be deceived that we are referring to one and the same. Okay? That's the test of dominancy. Dermalin, prevalent features. A holistic test, it would now subject trademarks, okay, to entirely different features. Paano po yun? Okay. So in this particular case, ang ginamit po ng court natin is the test of dominancy. Okay. So the Supreme Court affirmed the IPO's application of the dominancy test while noting down the differences between the competing marks. Yung isa dalawang linya, yung isa may E, yung isa walang E. Okay, paano siya naka-angkla, naka-incline, yung isa ay talay sa ata, yung isa ay hindi. Okay, pero, okay, the first mark is written in an upright font while it actually distinguishes how those two signs would look like. Magkaiba. Okay, apparently magkaiba. Pero sabi ni court, the court nevertheless found likelihood of confusion. Okay, ito po yung mga kadahilanan. The court noticed that the two word marks were identically spelled except that Dermalin's mark ended with the letter E. In addition, the marks were practically pronounced similarly in 3 syllables, with the last letter E of Dermalin's mark pronounced silently. The court also pointed out that when an ordinary purchaser hears an advertisement of Dermalin's trademark over the radio, chances are the said purchaser will associate it with Myra's registered mark. Kaya hindi pwede. The court explained that while Dermalin's products did belong to a separate and different classification, okay, may Section 5, may isa Section 44, that did not forestall the possibility of confusion, especially since both marks denote products dedicated to treating the skin. Okay? So, when is there infringement? Tingnan po maigi dito. Any person without the consent, use in commercial, any reproduction, okay, yan. A registered mark in connection with the sale, offering for sale, distribution, advertising, with which such use is likely to cause confusion, mistake, or to deceive the public. When is there infringement? Okay, ito, reproduce, counterfeit, copy, or colorable imitation of a registered mark or a dominant feature thereof, and apply such reproduction, counterfeit, copy, or colorable imitation to labels. So, ginamit mo talaga yung hindi naman dapat sa iyo, okay, dito sa mga products mo. And it will now, likely cause confusion to the buying public. That's infringement. Okay. Still, another kind of infringement. Any person who shall employ deception or any other means contrary to good faith. So, this is an example of bad faith po. Talagang may intensyong mangloko. Okay. Use of any article or device calculated to induce the false belief that such person is offering the services of another. Okay. Yan po yan. Making false statement in the course of trade or commit any other act contrary to good faith or discredit the good services of another. Still, okay, those that are likely to cause confusion, those that are likely to cause mistake or to deceive as to the affiliation, connection, or association of such persons or services with another. Here is another case where what was applied was not a test of dominancy, but holistic test. Okay, Trademark Law 2 is already registered in favor of ABC for its product, edible oil. DAF, yung pangalawa po natin, applied for its registration for the same trademark, Lotus, for its own product. Ang kanyang product ay soy sauce, assuming, soy sauce, hindi sa edible oil. Assuming that the trademark applied for it is in smaller size, colored differently, of much smaller size, and set on a background which is dissimilar as to yield a distinct appearance. May the application, yung aking second application, be denied on the ground that its grant would likely cause confusion or mistake on the part of the buying public? Okay. Sabi dito, walang infringement. Okay. The application of DAF, the trademark Lotus, for soy sauce should be granted. Although the trademark Lotus is already registered in favor of. Okay. So, kasi bakit natin grant? Wala pong confusion. The rule is not whether the challenging mark would actually cause confusion, but whether the use of such mark would likely cause confusion on the part of the buying public. Okay? There is quite difference between soy sauce and edible oil. Hence, it can be said that DAF's trademark Lotus on soy sauce, okay, would likely not cause confusion on the part of the buying public. Okay? So, I think this is a case-to-case basis. Only that in this case, kay factual scenario, talagang yung una natin, ang kanilang produkto lang talaga ay edible oil. Okay? So, yung second naman natin ay ito naman yung produkto nila. Will your answer change if in addition to edible oil, meron ding mga ganitong sauces, okay, soy sauce na ginagamit siya? Then in that case, yes, then there will be infringement. And of course, we cannot extend this protection under the law to the second applicant. Okay? So there are remedies available to owners of registered marks from infringers, such as those remedies that are availing under the civil and criminal law natin. Okay, so may mga civil actions tayo, may mga criminal actions tayo for infringement, for unfair competition, for false or fraudulent declaration, and false designation of origin. Okay, so again, civil actions, criminal actions. There are also administrative actions before the Bureau of Legal Affairs of the Intellectual Property Office for violation of, okay, intellectual property. Meron ulit tayo doon na administrative counterpart ng infringement ng unfair competition ng false designation of origin under the provision, of course, of the Intellectual Property Code and under, you might now be hearing me mention this, okay, inter partes cases. Partes cases. Okay? So, mga inter partes cases kasi, between parties na cases. Okay? May mga opposition, may mga prayer to cancel, okay? And all, those are possible administrative remedies, no? Dagdag pa natin yung mga border measures natin under the Bureau of Customs. Yung mga papasok, mga imports natin ng goods. Okay? Oh, if it is likely to cause, again, our following all those characteristics that I've mentioned a while back, likely to cause confusion on the part of the buying public. Then, right from that, okay, sa may port pa lang, border measures, okay, we don't give them right away. We don't give them this right to their intellectual property rights. Distinction po ng infringement versus unfair competition. This is another favorite portion. Rich source of questions that may be asked on the law on trademarks. Ano yung distinction ng dalawa? Trademark at unfair competition. Okay? So, infringement of a trademark is the unauthorized use of the trademark, whereas unfair competition is the passing of one's goods as those of another. Okay? Fraudulent intent is unnecessary in infringement or trademark, whether fraudulent intent is essential, whereas fraudulent intent is essential in unfair competition. The prior registration of the trademark is a prerequisite to an action for infringement of trademark, okay, whereas registration of the trademark is not necessary in unfair competition. Okay. Points of distinction between the two. The nature of the offense, the nature of the cause of action. Magkaiba, malaking pagkakaiba, no? Yung isa yung unlawful, unauthorized use. Yung isa, pinapass off mo yung goods mo as those of another. Existence of fraudulent intent, where is this essential to make it a case of that? Sa unfair competition po, fraudulent intent is essential, not the same in infringement of trademark. Another point of distinction, the need for registration of the mark. Pag trademark, of course, kailangan prior registration yan. Pero pag unfair competition, registration is not necessary. Other points of distinction. as to the classes of goods involved. Okay? Pag infringement, must be of similar class. Pag unfair competition, it not be the same. Okay? Let's try to do recapping before we end this part 1 on intellectual property code. Trademarks, service marks, and trade names owned by persons, corporations, partnerships, or associations domiciled in the Philippines or in any foreign country may be registered with the Intellectual Property Office. Okay, if you take a look at that, okay, maybe, no, permissive naman yung tinatanong. Although we know that trade names, okay, hindi yan hinihingi ng Intellectual Property Code, yung application for registration ng trade names. We know this, it has been mentioned a while back. Trade names are protected even before or without registration. Pero of course, we know that marks, kailangan may registration to enjoy protection. Yan. First in, first out. Okay, let's go on. Validity, the term of protection, 10 years, 10 years. Renewable. And the requirement for declaration of use to be submitted within those period of time. Starting this date, a declaration of actual use should also be filed with the Intellectual Property Office within 1 year from the renewal date in order to maintain the trademark registration. Kahit sa renewal yan, kailangan pakitaan ng declaration of actual use. Problem, Lucky Me registered its trademark, ang sarap pansit palabok, with the Intellectual Property Office missing. The second one, subsequently introduced its new product, ang sarap Pinoy ramen. Okay? Lucky Me sued for trademark infringement. Is this a case of trademark infringement? What do you think? Okay. Yes, it is guilty of trademark infringement. Cancellation of trademark or trade name. Who may file for this cancellation? Anyone who believes that he is and will be damaged by the registration of the mark were to file the Bureau of Legal Affairs of IPL. What are the grounds for cancellation of trade name or trademark? When the mark becomes generic for goods which is registered, abandoning of the mark, registration obtained fraudulently or contrary to provisions of that particular special law. It is mark used by or with permission of registrant. Failure to use the mark within the Philippines for 3 uninterrupted years or longer. Okay. So we continue with the other intellectual property rights in the next slides. Okay. So bye for now for the law on. Okay, this is the law on trademarks.